For refer to the special mediation cases, item 12 from supplementary list, second appeal 8 of 2017. Item 12, supplementary list.
Also for the appellant is absent. Yes, nobody appears on behalf of the parties. In such circumstances, this court is not in a position to refer the matter for mediation today. So ऐसा matter. Parties absent, post under the same heading on Tuesday in supplementary cause list. Next call करिए.
Item 13, second appeal 14 of 2017.
13. Same.
Item 14, second appeal 202 of 2017.
It's a second appeal. The judgment of two courts being are against the second appeal has been admitted. It may not be said it will be kept for an adjudication.
Cannot be settled through mediation. Why? ऐसा कौन सा dispute है जो mediation से नहीं settle हो सकता? हाँ?
If my friend is agreed, I don't have.
Two countries are fighting and we are talking about mediation. You say आप कहीं छोटा सा second appeal.
Friend is ready, मतलब I am ready.
वैसे
हम तो लैंडलॉर्ड है तो बोल रहे खाली का ऑर्डर खाली नहीं करें. खाली तो नहीं करें. खाली नहीं.
इंस्ट्रक्शन लिए हैं क्या कि खाली नहीं करेंगे?
जी.
बताइए आपको इंस्ट्रक्शन है तो भेज सकते हैं. नहीं इंस्ट्रक्शन है तो मत भेजते हैं. क्या कर सकते हैं?
Well, it may not be said. It will be decided by this honorable.
The learned counsel for the appellant is not ready for mediation. The second appeal, he submits that the matter may be decided on merits. Post this case for final disposal day after tomorrow. चलिए.
मतलब इसको कुछ टाइम दे दिया.
कोई टाइम नहीं देंगे. मीडिएशन आपको चाहिए नहीं, परसों आप बहस करिए.
If my friend is ready, I am ready for mediation.
What do you mean if he is ready? I just can't get it.
एक बार ट्राई करें. हम तो रेडी हैं. हमको सिर्फ मेरा घर खाली चाहिए. इसमें कुछ इनको पैसा का भी ऑर्डर होता तो पैसा इंस्ट्रक्शन हम आई कैन एश्योर कि पैसा.
यहाँ पे जो मीडिएशन के लिए मना करेगा दूसरा दिन केस डिसाइड करेंगे. आपको क्या लगता है? पेंडेंसी का बेनिफिट किसी को इसलिए नहीं मिल सकता है कि कोर्ट डिसाइड नहीं कर रहा है. और दो तरह के मैटर्स खास तौर पे, लैंडलॉर्ड टेनेंट रिलेशनशिप एंड स्पेसिफिक परफॉर्मेंस ऑफ ये तो बस दूसरा ही दिन डिसाइड होगा. These are short matters, इसमें ज़्यादा कुछ करने को होता नहीं. भेज देते हैं. चलिए. With the consent of the learned counsel for the parties. The matter is sent to कल वही वाला जो mediation drive है ना, इसमें इसके अनुसार 3-4 तो ऑर्डर किए हैं. ठीक, send for mediation. Office to do the lead.
Item 15, second appeal 258 of 2017.
Yes.
But
क्या
I will
विचार है
take
आपका?
it- I will take instruction. But Tuesday को रहने दीजिए. But हम पूछ लेंगे पार्टी.
क्या है?
देखिए मीडिएशन वाला में तो हम क्योंकि एक बार इंस्ट्रक्शन ले लेते हैं, सेटल तो हो जाना चाहिए दोनों.
भेज देते हैं.
हाँ ठीक है तो भेज
और-
कर देंगे क्या फिर.
पार्टीशन
हाँ तब तो बहुत बेटर है, दोनों एक ही फैमिली दे रहे हैं.
mediation का चांस है.
हाँ
appearing on behalf of respondent. It cannot be settled through mediation.
कब करिएगा बहन साहब? बताइए.
On Monday.
सेकेंड अपील है.
सेकंड
ग्राउंड कौन से ग्राउंड पर एडमिट हुआ? सब्सटेंशियल क्वेश्चन ऑफ लॉ क्या है इसमें? बताइए. वेरी गुड. अभी तक तो इसमें सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं बना है. क्या चल रहा है इस प्रोसीडिंग में?
और तब तो और बेटर है नोट
और
सेटल हो
better
जाए,
है.
सेटल हो जाए डिस्प्यूट.
ने कुछ नहीं. अबेट भी कर गया है रिस्पॉन्ड नंबर 3 के अगेंस्ट में. वेरी गुड. चलिए अभी ऑर्डर 41-11 में आप बहस करेंगे.
हम तो फाइल
वो तैयार नहीं है ना, कैसे भेजें?
नहीं हम यही प्रे कर रहे हैं. मीडिएशन ड्राइव में नोट भेज दिया जाए, उसके बाद कोई डेट लगा दिया
अरे
जाए.
वो मान ही नहीं रहा तो क्या करें? अदर साइड नहीं मान रहे हैं तो हम क्या करें?
और तब इसको नेक्स्ट वीक रख दिया.
ऑर्डर 41-11
ऑर्डर
Essay number 258 of 2017. Counsel for the parties are present. The counsel for the respondent has submitted that the matter may not be referred to mediation. Office is directed to place this case under the heading hearing under Order 41 Rule 11 CPC on Tuesday. Next.
Serial 12 में मीडिएशन में
कौन सा?
सीरियल 12
उसका क्या करें?
मीडिएशन में
भेज दें? कौन है अदर साइड?
अदर साइड से आदमी को लिए तो फर्स्ट टाइम बातचीत हुआ था उन्हें रेडी
दिखाई तो चले फाइल 12 वाला फाइल लीजिए. At the instance of the counsel for the appellant, let this matter be placed for mediation. Office to do the review.
Item number 13 was the partition should mark the partition should the advocate second appeal mark the to reversal
क्या
and the
करें?
absent mark
So,
for mediation mark
भेज दें?
the set the भेज दिया जाता है तो कौन सी
ये जो सेकेंड अपील का है ना 14 at the instance of the counsel for the appellant that this matter be placed for mediation. Office to be done. चलिए आ जाइए next.
Item 16, second appeal 262 of 2017.
With the consent of the counsel for the parties, let this matter be placed for mediation. Office to be done.
Item 17, second appeal 268 of 2017.
Respondent is not there. At the instance of the learned counsel for the appellant, let this matter be sent placed for mediation. Sent for mediation.
Item 18, second appeal 319 of 2017.
permitted to withdraw matter because plaintiff part they vacated the premises matter. So this is the emission.
Essay number 319 of 2017. Learned counsel for the appellant seeks permission to withdraw this appeal. Accordingly, this appeal is dismissed as withdrawn. Counsel for the respondent has no objection to the appeal.
Item 19, second appeal 440 of 2017.
At the instance of the learned counsel for the appellant, let this matter be placed before mediation. Office to be done.
Item 21, second appeal 515 of 2017.
Yes.
Parties are ready for mediation.
With the consent of the counsel for the parties, let this matter be sent to mediation.
Item 22, second appeal 367 of 2018.
Then on his
Item 22, second appeal 367 of 2018.
where is the appellant?
सब पार्टीशन है के लिए तो फाइल लेकिन टाइटल का इशू है
मीडिएशन में टाइटल नहीं डिसाइड हो सकता है भाई इंडिया पाकिस्तान में मीडिएशन हो सकता है, तब क्या बात कर रहे हैं? पार्टीशन सूट घर के अंदर भेज सकते हैं, ट्राई कर लीजिए, हो जाता तो सकते। कोई भी डिस्प्यूट मीडिएशन में सॉल्व हो सकता है आज के ज़माने में, ठीक है? भेज सकते हैं, देख लीजिए। इसमें तो अभी तक सब्सटेंशियल क्वेश्चन ऑफ लॉ बना ही नहीं है, 2018 से पढ़ा ही हुआ है, तो क्या है? आपको तो कोई इंटरेस्ट भी नहीं है। 2-4 लोग मर भी गए होंगे पार्टीशन सूट में। 2018 कितने साल हो गया, छोड़ के रख दिए हैं। क्यों ही फाइल करते हैं केस? Why do you file the case? Why at all did you file the case?
फाइल तो हुआ था, चैलेंज कर दिया
तो क्या हुआ उसके बाद? चैलेंज का रिगर्स खत्म हो गया है, nobody is interested।
नहीं इंटरेस्टेड है,
ऐसा इंटरेस्ट होता तो 2018 से क्या अभी डिफेक्ट में चलते रहता केस?
डिफेक्ट में नहीं
फिर क्या है? डिफेक्ट रिमूव कर दिए, बहुत बड़ा एहसान कर दिए हैं, और क्या कर सकते हैं? These cases are burden on the court. जिस दिन केस ये अगर लग गया ऑर्डर 41 रूल 11 में नहीं आइएगा तो तुरंत डिसमिस कर देंगे।
हाँ
तो क्या करें हम इसमें? कोई इंस्ट्रक्शन भी है?
इसमें तो नोटिस भी नहीं हुआ, एडमिट ही ना हुआ।
तो एडमिट ही नहीं हुआ। वहाँ मीडिएशन में जाके ना वहीं से वो लोग नोटिस करेंगे, जैसा आपको पता चला है। आप बोलेंगे तो मीडिएशन में भेज देंगे, वहाँ से वो लोग नोटिस करेंगे, अपने आएंगे जो आएंगे जैसे।
एडमिशन में ही रहने देते, ऑर्डर 41 में रहने देते।
The learned counsel for the appellant submits that the matter may not be sent for mediation. Office is directed to place this case on Tuesday. Under the heading for hearing under order 41 rule 11 CPC.
Item 23, second appeal 6 of 2019.
At the instance of the counsel for the appellant, let this matter be placed for mediation.
Item 24, second appeal 57 of 2022.
Same amount.
In 23 will also go back because of the reason that
Item 25.
25 is also arising out of same judgment.
ये 25 वाला भी ना under order 41
No,
rule.
no,
देखिए किस
same
Mediation
judgment
में?
is-
Mediation.
ठीक है, इसको भी
Same
at the instance
judgment
of the
का
counsel
दो
for the
appeal है।
appellant,
along with
let this matter be
24,
placed for mediation.
25 एक साथ होगा।
ठीक, next बताइए।
Item 26, second appeal 179 of 2023.
Appellants are ready for mediation.
At the instance of the counsel for the appellant, let this matter be placed for mediation. Then next. कोई बात नहीं, वहीं से वो लोग नोटिस करेंगे, ठीक है? Let's find out कि क्या हो सकता है, जैसे डायरेक्टिव है। Next.
Item 27, second appeal 183 of 2023.
At the instance of the counsel for the appellant, let this matter be sent for mediation.
Item 28, second appeal 189 of 2023.
Same order. Next.
इसमें आगे वाली फाइल के अंदर मतलब तो प्लान नंबर 1 उसको डिलीट करना है, तो देख करके सबको मिल जाएगा।
28 में ना, ठीक है, IA number 3871 of 2025. The learned counsel for the appellant submits that the petition has been, the interlocutory application has been filed for deleting the name of
अपील नंबर 1
appellant number 1.
all the legal heirs जो बोर्ड का
All the legal years and successors of appellant number 1 are already on record. Considering the submissions, IA number 3871 of 2025 is allowed. Appellant is directed to delete the name of appellant number 1 from the cost act. देख के बता रहे हैं ना आइए।
जी जी देखिए
ठीक, आप डिलीट कर दीजिए। At the instance of the learned counsel for the appellant, let this matter be sent for mediation.
करेक्शन कर
करेक्ट करेक्शन करके जाइए। आइए डिस्पोज्ड ऑफ। नेक्स्ट।
Item 29, second appeal 190 of 2023.
नंबरिंग हो जाएगा मैं लोग
कौन रीनंबरिंग कुछ करने का जरूरत है?
The other side has not appeared, so
वहाँ से नोटिस होगा, वहाँ appear हो जाएगा। At the instance of the counsel for the appellant, let this matter be sent for mediation. Next order, please number.
Item 30, second appeal 207 of 2023.
Nobody is appearing on behalf of the appellant. Yesterday also nobody had appeared. Office is directed to place this case under the heading for, बताइए तो कौन सा heading में जाएगा ये? Order 41 Rule 11 on Tuesday.
Item 31, second appeal 233 of 2023.
Appellant? Yes? I can't get you. Yes?
Waiting for 3 weeks time to remove the
Remove the defects. Mediation में जाना है तो बोलिए. Learned counsel for the appellant submits that the appellant is not agreeable for mediation. However, he prays for and is granted (2 weeks) time to remove the surviving defects. If the defects are removed within time, office is directed to place this case under appropriate heading on 7th of August.
Item 32, second appeal 243 of 2023.
Appellant essay number 243 of 2023. Nobody appears on behalf of the appellant. Yesterday also, appellant was absent. Office is directed to place this accordingly, the matter will not be sent for mediation. The appeal is defective. The counsel for the appellant is granted 4 weeks time to remove the surviving defects prematurely. If the defects are removed within time, office is directed to place the case before under appropriate heading on 13th of August, 27th of August. A soft copy of this order will be forwarded to the counsel for the appellant for compliance.
From supplementary list case for final score item 1, first appeal 43 of 2012.
We'll start with the last argument which they made yesterday. Well, that argument also was
You are for respondent number
10 to 15.
10 to 15,
Defendant
defendant
number
number
5 to 10.
5 to 10. And 5
So
is
thus,
10. 10, 7. You joined the argument, right? You are addressing first point. बताइए कौन सा point आप addressing?
लास्ट आर्गुमेंट ये किए थे कि जो कंपनसेशन केस था उसमें जो फाइंडिंग्स है that will act as a res judicata for us. We cannot dispute and therefore we stopped from objecting in this suit. Our argument will be hit by res judicata. So that, with due respect, I say that that is not a correct position of law. Also, similar provisions are contained in various other lordships that act similar to lordships Land Reforms Act of Bihar. Like one act is Tamil Nadu State's Abolition and Conversions of Raiyatwari Acts. So in that the issue came for consideration. there also there was a provision, section 64, which says that suits are barred. What should we permit me to-
Suits are barred is another thing.
Yes, no, he said res judicata.
Res judicata.
Whether, what should we just,
He's not talking, he's not saying that the suit is barred.
no, it is his suit, he cannot say that it is barred. But Lord, the issue felt that whether the civil court can consider those. Lord, should can permit me to place from para 11 onwards. Three reasonings have been given in Lordships. May I read out his? It will be seen that elaborate provisions have been made in the enactment to carry out the main objective and other purposes of the Act, and Section 4 to 8 deal with constitution of authorities like tribunals and Board of Revenue and appointing various officers such as Director of Settlement, Settlement Officers, Managers of State, etc. to carry out the functions and duties assigned to them under the Act. It will be pertinent to observe that in between the provisions dealing with the grant of Rayatari, they call it Rayatwari Patta to a Rayat, and the grant thereof to a landholder where there is a difference of vital significance. Whereas in the case an application for a Rayatari Patta is made by a landlord under section 12, 13, 14 and 14 section 15, in term enjoins a duty upon the settlement officer to examine the nature and character of the land and history thereof, and then decide whether the claim of the landlord should be allowed or not. And in the case an application of Rayatari Patta by a Rayat under section 11 is there, is no similar express provision for any inquiry into the nature and character of the land, granting or refusing to grant such patta to the applicant. Even if section 11 is read with the proviso of clause D of section 3, whereas some inquiry is contemplated before granting Rayatari Patta to a Rayat, there is no provision of directing an inquiry for ascertainment of character of the land, namely whether it is a Rayati land or a communal land, and the settlement officer's decision on this aspect will be incidental to and impliedly rendered only for the purpose of granting or refusing to grant the Rayatari Patta. There is also also this further difference that the settlement officer's decision on the nature and character of the land under section 15 is subject to regular appeal to a tribunal under section 2, while the settlement officer's decision grant or refuse to grant a patta to Rayati under section 11 is subject to be revised by the director of settlement under section 5 by the board, also by the Board of Revenue under section 7C, and the relevant rules made on behalf of the decision of the and the decision of the director settlement in division is further revisable by Board of Revenue under 7D of the Act. Then comes section 64C, which accords finality to the orders passed by the government, and that the authorities under the Act, which we have earlier quoted in extension. Now turning to the question raised in these appeals is for determination. It is true that section 64C of the Act gives finality to the orders passed by the government and other authorities in the matters to be determined by them under the Act, and subsection 2 provides that no such order shall be called in question in any court of law. Even so, such provision by itself is not having regard to the two propositions quoted above from Dulal Bhai case, decisive on the point of ouster of the civil court's jurisdiction, and several other aspects like the scheme of Dulal Bhai. Decisive on the point of ouster of the civil court's jurisdiction, and several other aspects like the scheme of the Act, adequacy and sufficiency of remedies provided by it, etc., will have to be considered to ascertain the precise intent of the legislature. Further, having regard to the vital difference indicated above in between the two sets of provisions dealing with grant of Rayatari Pattas to landholders on the one hand and Rayats on the different consideration, may arise while dealing with the issue of ouster of civil court's jurisdiction to adjudicate upon the true nature and character of the concerned land. Approaching to the question of this angle, it will be seen that first place section 64C itself in terms provides that a finality to orders passed by the authorities in respect of matters to be determined by them under the Act is for the purpose of this Act and is not generally or for any other purpose. As stated earlier, the main object of the Act is to abolish all the states and the intermediaries like Jamindars, Imamdars, Jagirs or under tenures holders, etc., and to convert all landholdings in such state into Rayatari settlements which operation in revenue parlance means conversion of alienated lands into non-alienated lands. That is to say, to deprive the intermediaries of their right to collect all the revenues in respect of such land and vesting of the same back in the government. The enactment and its several provisions are thus intended to serve the revenue purposes of the government by way of securing the government its sovereign right to collect all the revenues from all the lands and to facilitate the recovery thereof by the government, and in that process, if necessary, deal with the claims of the occupants of the land, nature of the land, etc. only incidentally in the summary manner, and that too for identifying and registering the persons in the revenue records from whom the recovery of revenue is to be made. The object of granting a Rayatari Patta is also to enable the holder to cultivate the land specified therein directly under the government on payment to it of such assessment cess as may be lawfully imposed by the land. Section 16 is clear that on behalf it imposes the liability to pay Rayatari and other assessment imposed upon the land to the government by way of Patta holder. The expression for the purposes of this act has been designedly used in this section, which cannot be ignored and must be given cogent meaning, and on plain reading of this section, which uses the expression, it is clear that any order passed by the settlement officer either granting or refusing to grant Rayatari Patta to a Rayat under section 11 of the Act must be regarded to have been passed to achieve the purposes of the Act and only revenue purposes, that is to say, for fastening the liability on him to pay the assessment and other dues and to facilitate the recovery of revenue from him by the government. And therefore, any decision impliedly rendered in this aspect of nature or character of the land on that occasion will have to be regarded as incidental to and merely for the purpose of passing an order for granting or refusal to grant a patta and for no other purpose. Secondly, this was the first reasoning. Secondly, the principle indicated in the second proposition enunciated in Dulha Bhai's case required that the statute, when it creates a special right of liability or provides for determination, also lay down all questions about the right or liability shall be determined by the tribunal or authority constituted by it, suggesting thereby that if there is no provision, it will be difficult to infer outside of civil court's jurisdiction to adjudicate all other questions pertaining to the right and liability. Since the notified date all the state vests with the government free of encumbrances, must be held that the land lying in such state, including the private land of the landowner and Rayati land cultivated by the Rayat, would vest in the government, and the act could be said to be creating a new right in favor of the landholder, that is the private lands, and the Rayats, reference Rayati land, by granting a Rayatari Patta to them. Section 12 and 15 and 11 respectively, the Act provides for determination of right of this by the settlement officer. Question is whether the Act also provides for determination of all questions about the right by the settlement officer. On this aspect, as has been indicated earlier, unlike in the case of an application for Rayatari Patta by the landlord under section 12, 13, 14, where inquiry into the nature of character of the land and history thereof is explicitly directed to be undertaken by virtue of 15 of the case of an application for a Rayatari Patta by the Rayat under section 11, there is no express provision of an inquiry in the nature or character of the land before granting or refusing to grant such patta by the applicant. It is true in some that some inquiry is contemplated. If section 11 reads with the provisos to clause D of section 3, even then there is no provision directing inquiry for ascertainment of nature of land, namely where it is a Rayat land, communal land, and is obviously impliedly to a decision in this aspect of a matter to be arrived by the settlement officer before he passes the order, either granting or refusing to grant such patta. Obviously, such decision rendered impliedly on this aspect of the matter will be incidental one, and arriving in a summary manner for the purpose of granting or refusing to grant a patta. A summary decision of this type in an inquiry conducted by revenue purposes cannot be regarded as final and conclusive so as to constitute bar to a civil court's jurisdiction, adjudicating upon the same issue arising in a suit for injunction filed by a Rayat on the basis of title or long or uninterrupted possession. Since the full-fledged inquiry in the trial nature or character of the land is provided under section 15 of the 15 in the case of application by landholder, the character of settlement decision on such issue may be different, but the question is not before us. Thirdly, having regard to the principle stated by this court while enunciating the first proposition in Dulha Bhai case, it is clear that even where the statute has given finality to the orders by the special tribunal, the civil court's jurisdiction can be regarded to have been excluded if there is an adequate remedy to do what civil court would normally do in a suit. In other words, even where finality is accorded in the orders passed by the special tribunal, one will have to see whether such special tribunal has the power to grant relief which civil court would normally grant in a suit, and if the answer is in negative, it would be difficult to imply or infer exclusion of civil court's jurisdiction. Now take the case of the appellant who has applied for Rayatari Patta under section 11 staking his claim thereto on the basis of his long uninterrupted possession of the Rayat land. But the settlement officer on the materials before him is not satisfied that land in question is a Rayat land. In that case, he will refuse the Patta to the applicant. But can he, even after refusal of the Patta, protect the applicant's long uninterrupted possession against the government's interference? Obviously, he cannot, for it lies within its power and jurisdiction merely to grant or refuse to grant Patta on the basis of the materials placed before him. But such a person, even after refusal of Rayatari Patta, would be entitled to protect his possessory title and long enjoyment of the land, and to seek an injunction preventing government's interference otherwise than in due course of law. And surely for granting such relief, civil court may have to adjudicate the real nature and character of the land if the same is put to issue. In other words, since the settlement officer had no power to do what civil court normally do in a suit, it is difficult to imply outside of civil court's jurisdiction simply because finality has been accorded by the settlement officer's order under section 64C of the Act. Therefore, Lordship, we have laid evidence that we were in uninterrupted possession. But that power was not vested with the settlement officer.
So you are not seeking adverse possession, are you?
Lordship, we are objecting to the suit. Now we are saying that whatever they say, they have not been in possession. That is a fact we have pleaded, we have proved by our evidence, and there is no cross-examination to that effect.
There is a finding that you are in possession of the property.
Lordship, we have laid evidence, no cross-examination.
Is there any finding that you are in possession of the property?
No.
There is no finding.
There is no finding.
There is a
about
finding that the plaintiffs are in possession of the property.
Yes, yes.
There is a finding.
Finding. Therefore, Lordship, the judgment is impugned before your Lordship. Lordship will have to see.
You are not the appellant.
Lordship, for that, if your Lordship sees one provision of CPC, Lordship, whether I am an appellant or not, if I was a party in a suit and I have been made a party in the appeal, Lordship, can you see the provision that is Order 41, Rule 33 of CPC? I was coming to the next one because that was the first thing he opened his argument with.
That's right. It's a sequel
Power
to
of-
this. This question is a sequel to what you are.
Yes, yes.
Order number.
Order 41, Rule 33.
Order 41.
Rule 33.
Yes, please.
Power of Court of Appeal. The appellate court shall have the power to pass any decree and pass an order which ought to have been passed or made or passed or make such further or other decree or order as the case may be required, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, or may be exercised in favor of all or any of the respondents or parties, although such respondent or parties may not have filed an appeal or objection, as may where there has been decrees in cross suit or two or more decrees passed in one suit be exercised in respect of all of the decrees, although an appeal may not have been filed in such decrees.
See, the appellant is there, right?
Actually, even if I have not been made a party, but your Lordship, while considering, because it is the first appeal, Lordship will reappreciate everything as if Lordship is deciding the suit. In that purpose, if your Lordship finds that a decree in the interest of justice was required to be passed on the basis of obedience in some other manner, irrespective of the fact that the beneficiary of that decree might not have challenged that judgment, Lordship will do so. Lordship will reappreciate it because it is the first appeal.
So the appellant is also not claiming possession.
We have claimed, we have laid evidence and show the
That's
evidence.
right. Appellant is not agreed so far as the possession is concerned. They are only agreed by the
Yes.
title.
Lordship, therefore I started the argument when I was arguing, Lordship, that there may be an instance where neither parties have filed any written statement, neither parties have laid any evidence. Okay, that will be the extreme situation. In that case also, Lordship, only because the other parties have not filed any written statement, Lordship, other parties have not, or there is a written statement not expressly denying. Lordship, in those cases also, Lordship will
See,
examine
in
whether.
this appeal,
Yes.
the point of possession is not coming into picture.
Lordship,
That is not the matter for consideration. Only the title is under
Lordship,
consideration. Possession is not under consideration because the appellants are not claiming possession.
So
They are
appellants
not in
claiming the
possession of the
suit property. The admitted fact is suit property is beyond what the appellants have been claiming. Suit property consists of a huge chunk of land involving various haywards, various plots. Now, Your Lordships, the main illegality in the admitted case of the respondents, they are in the plaint. If Your Lordship sees the plaint for a moment once again. Why? First, Your Lordship, if I am able to, I have been
The
able
first
to
first you finish the first point and then we move.
First point is, Lordship, even if I have not filed a separate appeal. If I am a party and I
No,
am,
that is not the first point. You were referring to this judgment.
yes, this judgment
And
says,
show
Your
me that
Lordship,
there is a parameteria provision in Bihar Land Reforms Act.
Lordship, permit me to place certain provisions of Bihar Land Reform
Yes,
Act.
please.
Lordship, will kindly come to section 4.
Consequence of vesting.
Yes, Lordship, will first come to section 3. Notification of vesting. The state government may from time to time by notification declare that the states and tenures of a proprietor or tenure holder specified in the notification are passed and vested in the state. Thereafter, the details of notification, Lordship, will thereafter come to section 4. Consequences of vesting. There also, Lordship, the Honorable Supreme Court considered the consequences of vesting. Notwithstanding anything contained in any other law for the time being in force, or any contract, or notwithstanding non-compliance or irregular compliance of the provisions of section 3, 3A, 3B, except provisions of subsection 1 of section 3 and subsection 1 of section 3A, on publication of the notification under subsection 1 of section 3 or subsection 1 or subsection 2 of section 3A, the following consequences shall ensure and shall be deemed to have ensured normally. A. Such state tenure including the interest of the proprietor or tenure holder in the building or part of the building comprised in such state or tenure, or primarily as office or kachari for the collection of rent of the state or tenure, or his interest in trees, forest, fisheries, jalkars, hart, bazaars, ferries, and all other Sairat interests shall also in interest of subsoil, interest in all subsoil, including any right in the mines, minerals, whether discovered or undiscovered, or whether being worked or not inclusive of such right of a lessee of a mines or minerals comprise in such state or tenure, other than the interest of the riyats or under riyats, shall have the effect on the date of vesting vest absolutely in the state. Which is similar language? Absolutely in the state, free from all encumbrances, and such proprietor tenure holder shall cease to have any interest in such state or other than the interest expressly saved by or under the provisions of the Act. All rent, cess, royalties accruing in respect of the land comprised in such state or tenure on or after the date of vesting shall be payable in the state and not to the outgoing proprietor or tenure holder, or any payment made in contravention of this clause shall not be binding on the state government. So pause here for a moment. First, their pleading was, Lordship, that the tenure holder rights were mortgaged, which I had shown the plate in detail, and Lordship, that. So that has also vested. If they say we acquired the right of that tenure holder by invoking the mortgage deed.
Yes.
Now, Lordship, can we come to 4H? The 4th, the CC, if your Lordship sees first. In case of outgoing intermediary have recovered any amount from the tenant.
Show me the language that compensation is for the purposes of this act or this
Lordship.
kind of a specific inquiry, that the inquiry is
But
for
I
the
was showing the
purposes of
effect,
the act.
Lordship.
Because bar to jurisdiction is under section 35.
34. Yes.
35.
34.
And the bar is only a limited bar.
Bar to jurisdiction of the courts in certain matters.
It's a
No
very
suit
limited
shall be
bar.
no suit shall be brought in any civil court in respect of any entry or omission from a compensation assessment roll or in respect of order passed under chapter 2 or chapter 6 concerning the matter which has already been subject to any application made in the proceedings taken. The bar is very limited. There the bar was not so.
It has a limited bar in the sense this compensation etc. when fixed,
Yes.
the assessment rule once determined,
Yes.
that particular aspect cannot be
Yes,
changed.
one cannot by way
Now
of
the
suit
point
for-
is when the compensation is fixed and you also claimed compensation, right? And that claim of your compensation was rejected, right? Once your claim of compensation is rejected, it means that they do not acknowledge your right to the land. Then under such
Yes.
circumstances, what is the consequence? Suppose your right is decided, okay? Then your right for claiming compensation will also remain.
No.
Why
Just,
no?
just
Because
Lordship,
you are
compensation-
entitled to compensation,
I'll just
otherwise.
explain you, Lordship. Compensation is against what? Lordship, compensation is against three things. First, Lordship, the right to collect rent, which I was collecting from my rayas, that gets forfeited. So I have to be compensated once. Two, Lordship, right to hold the forest land or other common land, other things, that gets forfeited. My income from those gets forfeited because now the state will earn from those, or mines. Third, Lordship, the land which I was holding, which I cannot hold anymore, and it will vest with the state government. So against that. So once those part are those, either party, either I or the respondent plaintiff, they both, in the consequence of determination of compensation, lose the right. Right remains only one, that is right to claim compensation, which they have received the compensation. We cannot question it. That has attained finality.
Government has paid the compensation and they have received the
Received
compensation.
it, and those lands have vested with the state government.
That's right.
Those lands are not subject matter of this suit and cannot be made subject
So
matter of this.
suppose it is ultimately held in a suit that actually the title is with you, then under such circumstances you will be entitled for
Lordship,
compensation
therefore
also.
our first argument is they have not been able to show which
That
of
is
the lands-
another thing.
Yes.
When you are talking about bar to civil
Lordship,
jurisdiction,
bar to civil
what is
jurisdiction.
the nature of bar?
Lordship, bar is, Lordship, for the remaining land. Lordship,
No, we are not talking about any remaining land.
Lordship,
When
there is-
the
if there
property
is no
vests,
vest with the state government, then nothing remains.
nothing remains.
Then neither they have any right over any property, nor we have any right
It's not
over
that. It's not that they will not have right over any property. They will acquire a status, right? There could be some land where
Yes,
no
I'm
rent
coming-
is to be
I'm
paid.
coming
There
to
can
that.
be some land where rent is to be paid, and there can be a third category of land where the rayas will pay rent directly to the state. There are three categories
Lordship,
of
three categories. No rent has to be paid. That has been gone. That has been done away. There is no rent free
Then
land.
again, no. There are rent-free land, homestead land, rent-free land.
Homestead is rent free.
Yes.
Yes. Homestead is rent free.
Other land which was in possession of the direct possession of the landlord, they become the tenant, and rent is fixed
Only
so
to
far as
certain
those are
extent which is
concerned.
permissible, not the entire land.
The entire land, whatever be in their possession.
If the forest land was in,
Then the Land Sealing Act came into effect.
that is urban land sealing. That is
Urban
urban
land sealing. No, not that land. Not that Act. 1961 Act. What is that?
That is also land reform
Land
act.
sealing.
That is also Bihar Land Reforms
Land
Act.
reform sealing act.
No, that is also a ceiling is being fixed as to
Yes.
how much a
How much
property
land,
can be.
yes.
That is a separate thing altogether. But so far as Bihar Land Reforms Act are concerned, if one of the zamindar says that I have never appointed any rayyat, and the entire property was being cultivated by me only, right? Then under such circumstances, he will have the right to pay rent for the entire zamindar.
Then he will not get any compensation.
In that case also he will get. This is what I was saying. You see the
17.
definition of compensation.
Yes, Lakshmi, can you see?
Compensation includes every aspect of the matter.
Yes. It is a very vast meaning given to the compensation.
Yes, very vast meaning and very everything is included therein.
Yes. Actually, can we see?
Annual income, you just see the definition of
And yes,
annual
so if-
income, the net asset.
Not if I have not given anything on rent, then there is no annual income by way of rent.
How do you say there may not be any annual income out of rent, but
Yes.
there may be annual income out of the produce?
Produce is with respect to forest land and mines.
It's not like that.
If you lots of permission, just
We read it yesterday, you were not there.
I have seen the entire program. I have
Show
seen the
me,
proceeding.
show me where does it exclude and how is it excluded?
Actually, can we see Actually, can we go to section 19? To section 21 is the specific provision. Determination. This is 23. Computation of net income. For the
23 नहीं, 22 भी पढ़िए ना.
21 से ही पढ़ दे रहे हैं. Determine
21 is trust and for charitable and religious.
charitable and religious.
We are not concerned with that.
22 previous agriculture year and gross asset defined.
Yes.
For the purposes of this chapter, previous agricultural year means the agricultural year immediately preceding the year on which the date in which the date of vesting falls. Gross assets, when used in this reference to an intermediary, means the aggregate of the rents, including all cases where such which are payable in respect of the estate tenure of such intermediary for the previous agricultural year. But immediately subordinate tenant, in case of immediately subordinate tenant, is a tenure holder for the payment and reasonable tenure. The riots in all such other cases and includes.
आप पहले 2 तो पढ़िए ना. When used with reference to an intermediary means the zamindar, correct?
Yes.
Means the aggregate of rent,
Rents, including all
including
cesses.
all cesses, which were payable in respect of the
Estate and
estate.
tenure.
इसका क्या मतलब है? आपको पता है ना जमींदार कैसे होता था?
State भी जाता, state has a different meaning, tenure has a different meaning.
Tenure and state, yes, it has a different meaning. But the point is, what was the nature of zamindari? The entire land was given to the zamindar, and he had to give X amount of rent
To
to the superior landlord.
Superior landlord of the
Correct?
king.
Irrespective of the fact as to whether he is appointing any rajat or not.
Yes.
Bas. So therefore, it is for the entire estate. It is relatable to the entire state, and it is not relatable to only those rayats which he was collecting rent. Collection of rent by zamindar is totally distinct from liability of zamindar to pay rent. It has got no correlation. As per pre-abolition. Yes. So this is how it is calculated. You see the definition of gross asset, then you compute the net income, and the compensation is based on the computation of net income and gross asset.
If net income and gross assets, also income includes the income which I could get either by way of rent or by yes, that is there. Now I'll also take into consideration once I have been paid the compensation.
Yes.
Also, then my right to collect the rent.
Once the compensation has been paid to the plaintiff,
Yes.
right, then the entire state vests with the government. And now there are 3 categories. Category number 1, homestead etc., for which no rent is payable, but rent receipt will still be issued
By the state government.
by the state government, certainly. Second part is the zamindar's own land. That will be, zamindar will acquire the status of tenant and the rent will be assessed and paid, correct? And the third would be the rayats who were working under the zamindar. Now instead of paying rent to the zamindar, they will pay rent directly to the state. Bas.
So it is
So
not
therefore
there.
compensation is not calculated only on the basis of rayati rights created by the zamindar.
Very well. Now the issue is, also it is not their case stated in the print that they have not settled it to any rayats.
That's not their case.
now if that be so, they are seeking declaration of right title and possession with respect to the entire land. Now, Lordship, if they do not show, Lordship, there are other
They are only seeking their right pursuant to the option C.
Lordship,
And
that
their
we have-
cases,
yes, they have not been able
their
to.
cases, Dattas had no other right.
That is contrary to their own pleading. Kindly see the plaint. They say all their land, including 2% interest and other lands vested
Other
with
land
this
means what? That's absolutely vague. Pleadings has
But
got
admission,
no evidence.
it is
What
their admission that
other
they-
land. That is not admission. Vague admission. Other land means what?
Lordship,
You
they
tell
have-
us,
if there is
which
any, if there is a vagueness in the plaint, Lordships, then the plaintiff will suffer, not the defendants.
That's right.
Lordship, you kindly see that I had also shown it earlier also. They admit there were other lands.
That please don't repeat your argument. We
Yes,
are
yes.
noted.
Now, Lordship, the third argument is their admitted case as a now. First, they have not been able to connect.
No.
They gave
Please don't shift from one argument to another argument. First, complete your argument regarding exclusion of civil courts jurisdiction.
but
Now
the
you were referring to a judgment.
judgment, yes.
Now you compare it with the present provision to
Present
make it
provision
comparable
also-
and
yes.
applicable, and say that that particular judgment is applicable in this case.
Yes, Lordship may kindly see. Lordship has already seen this language of section 35.
You just refer it.
Lordship, section 35.
Yes, 35.
Here, section 35. I'm reading the language. No suit shall be brought in any civil court in respect of an entry in or omission from a compensation assessment rule, or in respect of an order passed under chapter 2 or chapter 6, or concerning any matter which is or has already been subject to an application made in the proceeding taken in this taken under these said chapters. Lordship, suit is barred with respect to an entry or omission in a compensation rule, or with respect to order with respect to compensation. Lordship, this judgment which I had referred, Lordship may kindly see section. Lordship, para 12. Now turning to the question raised in these appeals, for our determination, it is true that section 64C of the Act gives finality to the orders passed by the government or other authorities in respect of matters to be determined by them under the Act, and subsection 2 thereof provides no order shall be called in question in any court of law. Even so, such a provision by itself is not having a regard to the two propositions quoted in Lullabai's case, decisive on the point to ouster of civil court's jurisdiction, and several other aspects like the scheme of the Act, adequacy, sufficiency of remedies provided by it, etc., will have to be considered to ascertain the precise intendment of the legislature. Further, for regard of vital difference indicated above, the difference in between the two sets of provisions dealing with the grant of proprietary patrons and landlords on one hand, reyes on the different hand, may arise while deciding the issue of ouster of civil court's jurisdiction to adjudicate upon the true nature and character of the concerned land. Approaching the question with an angle, it will be seen that first 64C itself in terms provides that finality to the orders passed by the authorities in respect to the matters to be determined by them under this Act. Here also Lakshmi kindly see.
Where is 64C quoted? Where is section 64 quoted?
64C is not.
Where is it quoted?
It is not quoted here.
64C. It's here in para number 5.
5. Yes.
You read para.
64C.
You read para.
Counsel for the appellants before us has, in both the appeals, has relied upon section 64C of the Act and section 11 of the Act, which reads the definition of Rayati land given under section 316A, B and C of the Tamil Nadu State Lands Act 1908 for the purpose of contending that an order passed by the settlement officer in an inquiry under section 11 of the Act to be effect that in question is not Rayati land but Trumbo property communal land, and therefore no Rayatari Patta could have been issued in respect of thereof to the applicant has been given finality under section 64C of the Act. The same cannot be questioned by any court of law, and therefore civil court's jurisdiction to adjudicate upon the nature and character of the land must be regarded as having been outstayed or excluded by the legislature. In order to appreciate this contention, it will be necessary to set out the relevant provisions on which the reliance has been made placed by us, the counsel for the appellant. Section 64C of the Act runs thus: finality to the orders passed under this Act. Any order passed by the government or the authority under this Act in respect of the matters to be determined for the purposes of this Act shall be subject only to an appeal revision provided by or under this Act be final. No such order shall be questioned in any court of law.
See, there is a difference between the two. A person is entitled to grant a patta and a person is entitled for compensation on account of vesting are two different things altogether. You just see, suppose it is held that it was your property and you had the title. The consequence? The consequence is that the compensation has been wrongly paid to them. Right? What is the consequence? Suppose it is held that it was your property, then compensation has been wrongly paid to them. It has a direct bearing in the matter. The government is paying compensation for the acquisition of land through Land Reforms Act, and you participated in the proceeding claiming that it is your land. Your claim was rejected in order to fix their compensation.
My claim was rejected in order to fix their compensation.
Yes.
One. Now, Lordship, take into consideration whether that
And
was
you say that is not binding.
Lordship, they have to connect that compensation case with this.
That is a separate thing.
Yes.
That is a separate thing. That they have to connect that compensation case with this case. But you cannot say that compensation case has got no relevance.
No, it has no. I am not saying that it has no relevance. Barely because compensation is fixed.
And you see, it is one thing to say that you could have come to the court to say that I want my declaration of title and that compensation case will not bind me. It is not your suit. It is not your suit.
Yes.
So in his suit, you will challenge the compensation case.
Lordship, I am not challenging the compensation.
Compensation case is staring at you.
Lordship, it is staring at me, but my first argument is that has to be connected with the suit property.
That is a separate thing. That connection we have to see whether it is connected or not connected.
It is not connected, yes. One. Second, Lordship will take into consideration that it is a barely because revenue authorities have given a finding that cannot be said to have.
It is not revenue authority, Mr. Das. Fixing of compensation for acquisition of land under Bihar Land Reforms Act is not an exercise by revenue authority.
Intention of the act, the purpose of the act is.
The purpose of the act is twofold. One is to fix the compensation and second is to fix the rent. Fixation of rent is certainly revenue authority. There is no problem. Grant of patta, as in the case of this Tamil Nadu, is certainly an act of revenue authorities, no problem, because that is relating to collection of rent. But when it comes to giving compensation for the acquisition of land,
This judgment will help me, at least with respect to the findings which my learned friend was reading of the Deputy Commissioner's order. Though we say we also rely on the same judgment, wherein the Deputy Commissioner records the finding that even the Jamabandi opened in their name is doubtful.
that's right.
Yes. So in that respect also he cannot say that that finding is binding upon us. This judgment will come to our. Still, it has to be a matter to be determined by the civil court.
If Jamabandi opened in their name is doubtful, then under such circumstances the Deputy Commissioner ought to have asked them to deposit the compensation given to them.
Those have been taken out from my Jamamandi. That is the concept. Only 3 portions they have been taken out.
That's
Normally
right.
the monthly it has been taken.
That is the Sariat and
Rest is absolutely fine.
Actually, this suit property includes Sarat and all the lands. Actually, he has not said which are the properties which has been carved out. Lordship, there is absolutely no pleading, no evidence to show. Lordship, one more thing. Lordship, the suit has been decreed in toto in favor of the respondents, in mainly on the basis of the Form M. Admitted case of
that
the
is another point.
Yes,
Let
I'm
me
coming
just
to the other point. Lordship.
रुक जाइए थोड़ा लिखाने दीजिए.
जी.
The learned counsel for the respondent number 10 to 15 / defendant number 5 to 10 by way of rejoinder has taken up the point of res judicata at the first instance. He submits that the findings recorded in the compensation case will not act as res judicata as argued by the learned counsel for the respondent plaintiffs, and such argument is not a correct position of law. He has relied upon the judgment passed by the Honorable Supreme Court, reportedly bracket 1985 bracket close 4 SCC 10, to submit that bar to civil court jurisdiction in the matter of grant of patta under Tamil Nadu estate within bracket abolition and conversion into Rayatwadi bracket close Act 1948 was held to be it was held that the civil court's jurisdiction is not barred or excluded despite finality given to the orders of the statutory authorities. The learned counsel has raised the judgment from paragraph 11 to 14, and he submits that numerous reasons has been given to give such an interpretation.
The ultimate finding is para 16.
Para?
Para 16.
He has referred to paragraph 16 of the judgment, which is the ultimate finding. The learned counsel has referred to the provisions of Bihar Land Reforms Act, section 3, 4, (35) and the provisions under chapter 5 dealing with assessment of compensation.
So next argument is, they have also argued your lordship, and they have made it relied on the M forms. Admitted case of the lordship, there the argument is of twofold with respect to M forms. First is admitted case of the plaintiffs is they have filed 3 M forms. If your lordship sees scheduled to the plaintiff, they lordship under 5 head, item number 1, 2, 3, 4 and 5, lordship claim 5 set of properties under 5 different M forms. The suit has been decreed in toto on the basis of the M forms. When only I put a question to myself, when only 3 M forms have been produced, lordship, it the court below could not have decreed with respect of the entire 5 properties.
That's what.
That is an error which is apparent, Your Lordship.
That
stating
we
that.
have already noted.
Yes. Third, Your Lordship, in this only with respect to inform only, the next argument is, Lordship, I have read the evidence and there is no reply from their side that who proved this inform. Lordship, what they have done, they have filed those informs in some other unknown proceedings, obtained the certified copy of the same and filed it. These are not public documents. It has to be proved in the manner as prescribed under the Evidence Act.
This also I think they have argued. Repeat back to me.
नहीं उनका आर्गुमेंट ने वो लोग आर्गू किए उसी का रिप्लाई कर रहे हैं कि barely by production it could not have been marked as an evidence. It has to be proved in the manner as provided under the Evidence Act by some witness proving that yes, I have got it from here, giving us an opportunity to cross-examine it, but they have not done it. Third is
This
that
document was marked without any
without
objection.
it has been marked with objection. Kindly see, Lordship, the exhibit list which of the learned court below the record. It is
Informs were exhibit.
exhibit 10 series, and it has been marked with objection.
Better your lordship sees the order sheet itself.
But the subordinate, the
Without
learned
going
trial
into
court, no, you cannot read it.
No, because this is a serious allegation, therefore I say.
Yes.
If it
Lordship,
is
first come to
Exhibit 10 series.
Lordship, kindly come to
The
the
list of
exhibit.
exhibit.
The list of exhibits. Lordship, exhibit has the Lordship seen the exhibit.
It was marked when?
All were marked on the same day, that is 17/7/11. The 12/9/11. I beg your pardon, 12/9/11. Lordship seeing the exhibit list. Lordship
I'm
kindly
seeing the
come.
exhibit itself. Exhibit में भी कोई objection नहीं marked है.
Name, that is the error committed by the court. That is what we are showing.
Exhibit
Lordship, kindly
list.
come to the exhibit list. It is also a record prepared by the court, signed by the court.
Yes. They are coming to the exhibit list. Exhibit 10 series, right?
Lordship, may first come to exhibit till exhibit 5 to 5 by G. Lordship, may kindly see without objection. Has the Lordship seen it?
Into
So, exhibit 5 to 5 by G तक आया जिसमें लिखा हुआ without objection.
without objection.
उसके बाद exhibit 6 देखा जाए Lordship,
6
with objection. उसके बाद with objection के बाद नीचे जितना है do करके लिखते जा रहे हैं. हाँ. उसके बाद फिर exhibit 9 में देखिए with objection.
9 पे with objection नहीं है.
हाँ जी Lordship, हाथ से लिखा हुआ with objection. do के नीचे Lordship. 8 तक do है. उसके बाद 9 में फिर with objection.
9 में कहाँ with objection?
Just do का नीचे Lordship. WITH with objection.
5 में
Exhibit 9.
और किस दिन मार्क हुआ है ये?
12/9/2011.
देखिए सर. वो निकाल के दिए हैं आपको एग्जिबिट लिस्ट पलटिए. वो निकाल के दिए थे ना. Submission.
ये डिफरेंट नहीं 9 with objection.
नहीं 9 ये 9 नहीं है ना 10 सीरीज है ना
10 में आ रहे हैं 9 के बाद
9 में तो ऑब्जेक्शन किधर
यहाँ पे भी तो objection।
वो लेफ्ट हैंड साइड में कौन सा एग्जिबिट नंबर है वो वाला जो आपका राइट हैंड साइड का पेज है उसमें एग्जिबिट 9 है ना
जो यहाँ पे भी एग्जिबिट 9 लिखा हुआ है वही कंटिन्यूएशन में है डिटेल्स आधा यहाँ मेंशन है यहाँ मेंशन है लेकिन यहाँ पे विद
और
ऑब्जेक्शन
10
और 10 में डू लिखे हैं विद ऑब्जेक्शन के
वो
नीचे
कितना लिखे हैं? दिखा इनको हाईलाइट कर रही थी दिखा ये ऑब्जेक्शन आप कहाँ से दिखा रहे हैं
हाईलाइट इधर पुट्स
हाँ
विद ऑब्जेक्शन को भी हाईलाइट कर दिए जहाँ डू लिखे हैं
ये तो विद ऑब्जेक्शन एग्जिबिट 9
हाँ उसके नीचे नेक्स्ट पेज आ जाएगा 9 कंटिन्यू किए वहाँ पे नेक्स्ट पेज में
अच्छा ये 12 9
हाँ 9 को कंटिन्यू किए उसके बाद 9A को भी डू लिखे 10 to 10C भी डू लिखे तो लक्ष्य अगर यहाँ पे लिस्ट ऑफ एग्जिबिट्स में वो ऑब्जेक्शन मेरा रिकॉर्ड किए हैं
इसको मतलब नहीं जब यहाँ पर है तो ऑर्डर शीट में भी पता लग जाएगा
हाँ ऑर्डर शीट में अगर नहीं लिखे तो दैट इज अ एरर कमिटेड बाय द कोर्ट
तो दोनों में से कौन सा एरर बनेगा
Lordship, this will prevail because we have recorded our objection and it was recorded at the time. Lordship, this is prepared at the time in the presence of the parties. Lordship, we record see the order sheet in presence of both the parties. In one day, all the documents were marked exhibit. That also I pointed out the irregularity.
नहीं ये इससे ज्यादा हम लोग ऑर्डर शीट पर विश्वास करेंगे ऑर्डर शीट में क्या है
Lordship,
इज इट
अगर
मार्क्ड विदाउट ऑब्जेक्शन
if order sheet में without objection लिख दिया यहाँ पे हम
लिखे हैं
लोग
कि नहीं लिखे हैं? पहले तो ये बताइए अब तो पता
नहीं
नहीं है
कुछ भी नहीं लिखे उसमें
प्रतिवादी को कोई आपत्ति नहीं
जब मेरा ऑब्जेक्शन
डेट
रिकॉर्ड
डेट बताइए
12/9/2011
एक ही दिन में सारा
12 9
2011
2011 Lordship, that order sheet I have shown to you Lordship in one day दोनों पार्टी का सारा डॉक्यूमेंट पे एग्जिबिट मार्क कर दिए that is just 3 months before giving the judgment after the evidence of both parties were closed
आपका भी तो एविडेंस वैसे ही फाइल हुआ
Lordship, हम लोग तो प्रूफ किए कोर्ट में हम लोग का वहाँ ब्लैंक छोड़ दिया गया marked as exhibit blank that was the duty of the court to put the exhibit number when the witness is being examined वो ब्लैंक छोड़ के कर दिया इनका तो कोई विटनेस प्रूव ही नहीं किया इन्होंने The normal procedure is when the list is prepared, Your Lordship, then parties are put. You are objecting, you are not objecting, and that is mentioned in the list. Later on, the order sheet is drawn on the basis of that list. It is not that list is made on the basis of that order sheet. So, if the order has been drawn on the basis of this list, and Lordship wrongly recorded that कोई objection नहीं है.
Lordship, it would be difficult to read that. If I may be allowed to read it and your Lordship may see from the order sheet. It is, he has written it in Hindi. May I read the entire order sheet of 12/9?
यस
उभय पक्षों की पैरवी वकालतन दाखिल किया गया। प्रतिवादी संख्या 5 से 10 की ओर से उनके विद्वान अधिवक्ता उपस्थित होकर निवेदन करते हैं कि दिनांक 9/9/11 के आदेश को संचालित कर निवेदन करते हैं कि दाखिल कागजात जो सूचना प्रपत्र फॉर्म परिसीमा प्रोजेक्ट मौजा रंगुनी एवं फॉर्म एम है जो लोक दस्तावेज है के अंतर्गत आते हैं जिसे प्रदर्शन अंकित किया जाए तथा प्रतिवादी संख्या 5 से 10 के विद्वान अधिवक्ता यह भी कथन करते हैं कि प्रतिवादी गवाह संख्या 5 कृष्णेंदु शेखर दत्ता ने रसीद संख्या 5 to 6 रिसीट सर्वे को अपने परीक्षण में समर्थन किया है जो प्रदर्श अंकित नहीं हुआ है, इसे भी प्रदर्श अंकित किया जाए। सुना, अभिलेख का अवलोकन किया, वादी पक्ष ने कोई आपत्ति नहीं किया, अतः प्रतिवादी संख्या 5 से 10 का प्रार्थना स्वीकार किया जाता है तथा मालगुजारी रसीद स्वयं को क्रमशः प्रदर्श A17 से A22 अंकित किया जाता है तथा 4 सूचना प्रपत्र फॉर्म परियोजना प्रोजेक्ट मौजा रंगूनी को क्रमशः प्रदर्श G, G1, G2 एवं G3 आपत्ति के साथ फॉर्म M 5 शीट्स जिसे प्रदर्श H, H1, H2, H3, H4 आपत्ति के साथ अंकित किया जाता है। Here can I place this here? They had also filed
yes,
these forms.
These same forms.
No,
वो अपना file किया।
हाँ वो अपना फाइल कर रहे हैं and all those are marked here for the first time without any evidence. Then वादी के विद्वान अधिवक्ता उपस्थित होकर दाखिल आवेदन दिनांक 1/9/2011 को संचालित कर निवेदन करते हैं कि दाखिल कागजात आदेश पत्र संख्या 565, 55-56 की सच्ची प्रतिलिपि प्रपत्र अंचल अधिकारी का एवं 4 एम फॉर्म अभिलेख पर मौजूद है जो लोक दस्तावेज के अंतर्गत है, इसे प्रदर्श अंकित किया जाए। सुना, तथा अभिलेख का अवलोकन से प्रतीत होता है कि उक्त कागजात लोक दस्तावेज के अंतर्गत है तथा प्रतिवादी को कोई आपत्ति नहीं है। That was inserted. कोई आपत्ति नहीं है, अतः वादी का प्रार्थना स्वीकार किया जाता है जिसे सच्ची प्रतिलिपि आदेश पत्र केस संख्या 565, 55-56 को प्रदर्श 9, सच्ची प्रतिलिपि अंचलाधिकारी का प्रदर्श 9/A एवं 4 एम फॉर्म जिसे क्रमशः प्रदर्श 10, 10A, 10B, 10C अंकित किया जाता है। वाद दिनांक को
That is what I am saying. Two things. When the list is first prepared on the basis of which order sheet is drawn, that is what I was submitting. So when the list has prepared and the court has recorded my objection.
कोई ऐसा CPC में प्रोसीजर है क्या? हम तो नहीं जानते कौन सा लिस्ट
वैसे
पहले
पहले
बनता है,
देखिए,
ये पहले
ये-
बनता है, क्योंकि लिस्ट में भी तो पार्टीज का साइन नहीं है, राइट? लिस्ट में भी पार्टीज का साइन नहीं होता,
List of parties का नहीं, judge का sign है.
जज का साइन।
And judge has recorded that we have objection to it. Now, Lordship, list was prepared, our objection was recorded. Now, while drawing the order sheet also, Lordship, initially when the order sheet was drawn, it was not mentioned that we don't have, later on that 4 words have been inserted, that आपत्ति नहीं है, प्रतिवादी को आपत्ति नहीं है. That will always, Lordship, cannot be, that is an error committed by the court. And when there is a contradiction by the same court, on the same day, in 2 documents, so then our objection has to be considered. It is without objection. It cannot be said to be without objection.
आपको कैसे ये आर्गुमेंट होगा हमको तो नहीं
Lordship,
समझ।
जो list बना है, Lordship, that is the
Yesterday he had pointed out one more provision,
Yes.
that if there is an interlocutory order in the proceeding and if you have to challenge it, that has to be specifically challenged.
Lordship,
Have you
but
challenged this, that this particular
we are
form
not
was?
the appellant, therefore
You
we
are
are
not
not
the
challenged.
appellant,
But
you are not
Lordship,
challenged.
Order 41, Rule 33, Lordship,
Then
see.
कैसे? No, there is no petition challenging it. What do you mean?
No, Lordship, there are two
When-
documents. There is
when-
no petition challenging that list also, which has been prepared by the court,
That's right.
wherein our objection is recorded. Now, Lordship will have to decide which will prevail, your Lordship.
Yes, we will decide. Okay, the learned counsel for the appellant has submitted that the 3 M forms which were produced by the plaintiffs and marked exhibit 10, 10 by 4 M forms which were produced by the plaintiffs at the stage of trial, which were marked as exhibit 10, 10 by A, 10 by B and 10 by C. On 12/9/2011, when seen in the list of exhibits prepared by the court concerned, they have been marked with objection. However, during the course of hearing, the order dated 12/9/2011 has been read, and as per the order, those exhibits were marked without any objection from the side of the defendants. The learned counsel submits that there is a mismatch in connection with order sheet dated 12/9/2011 and the list of exhibit. And so far as the exhibit themselves are concerned, objection has not been recorded on the exhibit, correct?
Yes.
Objection has not been recorded on the
It also does not mention
on the body of the exhibit.
Yes.
On the body of the exhibit.
Nothing is mentioned with or without objection.
Of course, nothing is objection has not been mentioned in the body of the document of the exhibit. He says that it has to be decided as to what will prevail. The order dated 12/9/2011, which shows marking of exhibits without objection, or the list of exhibits which was prepared by the learned court, showing documents with objection.
Next, you will actually take into consideration. My learned
Just a
friend-
moment. ए सीरीज वाला दीजिए तो ये वाला है डिपेंडेंस का
ये पेज 808 में है।
इसका पहला पेज भी डाल फर्स्ट पेज 67 366 पेज नंबर के बाद
पेज जो दिखा रहा है 808 पेज नंबर।
आपका डिपेंडेंस का एग्जीक्यूटिव
हाँ
लिस्ट
वही
है
हाँ 808 पेज नंबर में। The pencil
808
also in this portion 808 is written. Exhibit A to A5. A to A5 with objection.
जबकि ऑर्डर शीट में विदाउट ऑब्जेक्शन तो हम क्या माने तो आपका भी विद ऑब्जेक्शन मान
With objection मानने पड़ेगा. I cannot argue one thing and
during the course of hearing it also transpired that the ये सब तो विद ऑब्जेक्शन ही मार्क हुआ है आपका आपत्ति के साथ कोई डॉक्यूमेंट है जो आपका विदाउट आपत्ति मार्क हुआ है
नहीं हम लोग में तो सभी में विद आपत्ति है.
तो आपका सारा
सारा ही
ही
में with
डॉक्यूमेंट्स विद ऑब्जेक्शन है
हम लोग का मतलब हम लोग तो स्पेसिफिक बोला एग्जिबिट 5 का सीरीज था विदाउट ऑब्जेक्शन है हम लोग एडमिट करते हैं 6 onwards not to objection is there.
A17 to A22 rent receipt were marked without objection.
Yes, and rent receipt we had shown why without objection it does not contain any details of the land.
That's right.
While actually one more impression was tried to be created now while reading that order to show that हम लोग का inform भी हम लोग उसी समय दिए थे और हम लोग objection raise कर रहे हैं. So that is not what he said that हम लोग जो inform
नहीं
file
आपका
किया
इन्फॉर्म तो दूसरा है
और दूसरा नहीं इनका कहना हम लोग का एक आर्गुमेंट था कि एविडेंस क्लोज होने के बाद ये लोग अपना inform फाइल किए थे. ये बोले हम लोग भी अपना inform उसी समय फाइल किए थे as he tried to show from the order. The records is will show it is different. we filed our inform and all documents along with the list of documents as required.
But it was
order
not
to-
marked.
Lordship, not marked, the court
Easily
admits.
court did not.
Lordship,
It was
court
the
admits,
error of the
Lordship,
court.
yes, we pointed out that it was marked. Lordship, when we give the affidavit evidence also,
Yes.
we keep it blank for the court to
That's
fill up at that time.
The learned counsel has submitted that so far as the documents filed by the defendants are concerned, the court had omitted to mark those documents at the time of recording of the evidence,
Yes.
and consequently those documents were marked by the order dated 12/9.
Yes, when we pointed out that omission to the
When
court.
such omission was pointed out by the before the court, and it is not a case that the defendants had filed their documents after closure of their evidence.
It was filed along with the list as required under CPC, Your Lordships, on. Just to- It was filed on 13/12/2010 itself.
He submits that these documents were filed on 13/12/2010
2010.
along with a list of
List as
list of
required.
exhibits as required under CPC.
Order 13, Rule 1.
Order 13 Rule 1.
Now, Lordship, if they have not filed any document along with the list as required under the provisions of CPC, they have to take the leave of the court. There is no order sheet saying that any leave was sought for or was granted, but directly those were exhibited.
The learned counsel has also submitted that the documents which were exhibited from the side of the plaintiffs on 12/9/2011, no leave as such was taken, and they were directly exhibited. And there is a procedural lapse in marking those documents.
No, if Lordship permits me to place the deposition of the defendants. Plaintiffs have placed Your Lordship at the time of argument.
You are only giving your
Yes, yes.
rejoinder.
For
फिर
that,
से नहीं सुने.
only for that purpose.
What-
फिर से नहीं सुन रहे, हम वो
which
सब नहीं
point-
दिखा है.
Which point do you want to
So
address?
I want to show that we had
उनका कौन सा point आप respond करना
Lordship,
चाहते हैं?
to show that we had continuously been in possession, and Lordship, our ancestors had submitted the zamindari returns, which Lordship we have stated in our evidence, and that we have not, they have not cross-examined us on that. So those
We
findings.
will not permit that. This is
So
not
they have
your
argued on the ground of possession. I have to reply to that.
They have only said that there is a finding of possession in there.
Yes, I am showing to that Lordship that finding is perverse. If I
You
can
see,
show
the
that.
appellant has not challenged the finding of possession. They have not argued anything on the point of possession.
So therefore,
Not even a word they have argued.
Order 41 Rule 33 Lordship can permit us Lordship, because Lordship will have to
You
see.
see, if the appeal was by the plaintiffs, then certainly you would have got. Appeal is by a court respondent.
Despite
By
that,
co-defendant.
Lordship, despite that, Lordship, while deciding a first appeal, Lordship will see the entire evidence in entirety, and Lordship will re-decide as if Lordship is re-deciding the suit.
Irrespective of the appeal filed by any of the parties.
Yes, that is what Lordship is the provision. of.
Irrespective of who files the appeal.
Irrespective of whether Lordship a party is a appellant or a respondent in the appeal. So this is my submission. If a Lordship is not.
नहीं आपका सबमिशन तो हम सारा ही रिकॉर्ड कर
नहीं, वो तो record- Lordship-
ओपन एंडेड नहीं करना
नहीं,
कोई चीज
Lordship, accept whether your Lordship is accepting recording is another thing that we have no
कौन
doubt
कौन सा
about this.
पैराग्राफ बताइए और कौन सा डिफेंडेंट
But defendant.
क्योंकि you see at the first instance now I will have to again give them a response क्योंकि आप अपने initial argument में इस पर कोई बहस नहीं की so there was no occasion for them to respond जो चीज आप बहस नहीं किए हैं वो तो we don't expect anything from them isn't it now if you are raising new points in your rejoinder he will have a right to respond
I'll definitely respond because he has raised many things. I'll just show.
he will have to respond to that
Yes, I will not object. Lordship, in a proceeding ultimately for finding out or for doing justice, Lordship will hear the parties as many times.
Here as many times क्या हम लोग के पास खाली टाइम
नहीं,
है क्या
उसके लिए नहीं।
आपको मौका मिला था आपको रोके थे बहस करने से नहीं रोके थे ना सारा चीज बहस करना था आपको कि पोजीशन का फाइंडिंग मेरे अगेंस्ट में बट स्टिल आई वांट टू आर्ग्यू you should have said so you should have been conscious of this that there is a finding of possession against you और 4 बार हम सवाल पूछे हैं कि पोजीशन का फाइंडिंग किसका फेवर में। ऐसा नहीं है कि आई वाज नॉट कॉन्शियस ऑफ द फैक्ट, बट यू डोंट बॉदर अबाउट इट। रिजॉइंडर में पहली बार पोजीशन का कहानी दैट टू विदाउट बीइंग एन अपीलेट इन दिस केस।
Lordship, if Lordship permits me, I can.
Yeah, I will permit, but the point is just see how you are doing.
Lordship,
सही है ये, सही है। रिजॉइंडर में पहली बार पोजीशन का बहस,
क्योंकि Lordship पोजीशन पे हम लोग गए नहीं थे आर्गुमेंट में,
आप
लेकिन ये
क्यों
लोग
नहीं गए थे
reply में
भाई?
गए थे।
Who stopped you from raising an argument on possession? उस समय देखते हैं हम लोग क्या, इनको क्या रिस्पॉन्ड करना होगा, बताइए।
Lordship,
डिफेंड, पहले आप बताइए कौन सा डिफेंडेंट विटनेस?
Lordship, DW1.
DW1 पैरा नंबर
Lordship, paragraph 3.
3
Lordship, with respect to possession, paragraph 6.
6
Lordship, paragraph 11.
11
And this apart, we gave a specific statement in paragraph 6 that our predecessor in interest or our ancestors had submitted the returns on vesting of Jamindari. So those we have filed also.
returns were filed.
I had shown to your lordships also in the time of argument exhibit.
What
Also
is the
that
date? What is
Form
the
K.
date of filing return?
Form K. Exhibit E, lordship, I had shown to your lordship.
Date. Exhibit capital E.
Capital E.
Date.
Date also lordship I have put it on the. It was in 1980, lordship.
1980.
1980.
Exhibit E, Form K.
I beg your pardon, lordship. It is in case number 391 of 5657.
397 or 56, 57?
391 of 5657.
391 or
56,
57. This is your K form.
Yes, lordship had noted my argument also.
Yes,
I had
yes.
argued on this. So lordship, when this witness proved about that, as my predecessor in interest had submitted the Jamindari return, also there is no cross-examination by them. With respect to position also, there is no cross-examination by them. This apart, lordship, besides me, because I may be an interested witness, we examined two independent.
Who are you? DW1 is who?
Lordship, he is the defendant, your lordship, Ajay.
How is he?
Nimai Chandra Datta.
Achha.
He- This besides lordship, we examined two witnesses of the village, that is Ajay Kumar Mahato and Kedarnath Singh,
DW?
DW2 and DW3. They have also specifically stated two things. One, we are in possession. Two, the Pauls have no property, nothing, and no house, nothing in
Para
Maja
number?
Rangoli. Lordship, para 4,
Of DW2?
yes, para 4, para 8, and para 12.
Of DW2?
I beg your pardon, of DW3.
Para
DW2,
4,
your lordship,
8, 12.
and 12.
Yes.
And they have also been
And
crossed.
DW2?
DW2, para 4 and para 7.
4 and 7. No cross examination.
Cross examination, your lordship, they have stood the test of cross examination so far as DW 2 is concerned and 3 is concerned.
There was some cross examination.
Some cross. DW1 was also cross examined, but not on this issue. Whether my predecessor in interest submitted the Jamindari in interest, no cross examination. On respect of position also, there is no cross examination.
The learned counsel has submitted that though defendant number 5 to 10 have not filed a separate appeal, but the finding recorded by the learned trial court on the point of possession in favor of the plaintiff is not in accordance with law. He has referred to the evidence of DW1, paragraph 3, 6 and 11 and has submitted that and has also submitted that a reference was also made to Form K, which was filed in case number 391 of 56-57, which was marked Exhibit E. And there is no cross-examination of DW1 on the point of possession, who stated that his predecessor in interest were in possession of the property. He has also referred to the evidence of two co-villagers, DW2 and DW3, and has referred to paragraph 4 and 7 of DW2 and paragraph 4, 8 and 12 of DW3 to submit that they had also supported the case of the defendants with regard to possession of the suit property, and they have been cross-examined, but they have stood the test of cross-examination.
No, also exhibit B by 1 also with respect to possession only. So that was an inquiry conducted by the circle officer, who records in exhibit B by 1 that मैं अपने जांच के दौरान आवेदकों द्वारा दर्शाए गए आवेदन पत्र में जमीन का ब्यौरा जो आवेदकों को कब्जे में है ग्रामीण व्यक्तियों से पूछताछ किया और यह स्पष्ट होता है कि नारायण चंद्र दत्त और जीवन चंद्र दत्त के ही दखल में है. So he made an inquiry and that friends mentioned in
What is the date of inquiry?
it is in 1981.
The Learned Council has also
Order dated
referred.
is 16 to 1980.
The Learned Council has referred to Exhibit B.
B by 1.
Exhibit B by 1, and has submitted that the circle inspector,
Circle officer.
in his inquiry report has also confirmed that the defendant number 5 to 10
Yes.
were in possession of the property.
So this can I make the submission?
अब आपको क्या बहस करना है?
10 मिनट से ज़्यादा मंडे को नहीं करेंगे.
On what point do you want to argue?
Just miscellaneous of all the other things which he has approved. 2 or 3 others. But I'll formulate it and within 10 minutes I'll just point out a line, not more than 10 minutes.
Monday को?
कल उससे सेकंड ना बीडी का मैटर रहता है.
First of second आप ED का matter.
Friday को छुट्टी है. Friday there is a difficulty. आज भी लॉट्स there was a bad matter. I took the leave. I mentioned the court that the matter coming up. They have got it fixed on 16th.
Do you dispute the auction?
So auction, we say that auction does not anyhow contain.
Do you dispute the auction?
So we have stated in the other considerable point the plea taken is we are not aware of the auction.
Aware means what?
Therefore,
ये कोई जवाब है आपका?
नहीं ये तो वो लोग बोला जो प्लेंट में जो प्लीडिंग्स में वो बता दे रहे हैं. Also they have produced the certified copy of the order sheet showing auction. So they are finding as a counsel I say.
Auction तो हुआ?
Auction.
Sale certificate issue हुआ?
Sale certificate issue.
Possession certificate issue?
Issue. Yes. But there is a defect in all those certificates. Those do not specify the property which has been auctioned. So they say कि मौजा रंगूनी का 2.
अच्छा आप एक बात बताइए. ये जो प्रॉपर्टी आप क्लेम करते हैं, and you claim title over the property. What is the genesis of this title?
We say we have inherited this property from our ancestors.
Who ancestor? Inherited from whom?
The ancestors from whom they say we have auction sold, actually they admit that besides this property we had other properties also.
Who had?
We also sold. Plaintiff admits in the plaint. One. Second lordship, but we have also said the auction also lordship could not have been.
So your entire case is resting on other properties.
Our entire case is resting on the fact that plaintiff has not been able to prove their case. And if they have not been able to prove for the weakness of the lordship.
No, it is not that. You see, they have said that you had 6 annas of property.
6 anna share and
6 anna shares,
yes.
right? Do you claim that you have more share than 6 annas?
They say.
Do you say that you have more annas than 6 annas of property?
More annas no. 6 anna share. Lordship, there are 2 things there. Lordship, 6 आना share in the tenure holder as a tenure holder, and they say along it vested along
6
with
आना
other.
शेयर एज ए टेन्योर होल्डर कहाँ से?
So हम लोग तो 6 आना share tenure
कहाँ
holder
से? कहाँ से टेन्योर?
प्लेट पर दे रहे बच्चे.
टेन्योर होल्डर, अच्छा एक बात बताइए, होल्डिंग द एस्टेट एंड होल्डिंग टेन्योर होल्डर में क्या फर्क है?
Can you see the definition of both?
Yes.
State is normally लक्ष्य common understanding में
नहीं, कॉमन अंडरस्टैंडिंग से तो लॉ नहीं चलेगा ना.
लॉ का
लॉ तो लीगल अंडरस्टैंडिंग.
डेफिनेशन से पढ़ा था.
कॉमन अंडरस्टैंडिंग, कॉमन सेंस मेरा बहुत खराब है. आई डोंट बिलीव इन कॉमन सेंस. We have land laws.
लक्ष्य में कहनी सी 2Q is tenure, the TR is tenure holder, and I is state.
2Q.
2I first लक्ष्य state का definition है.
2I.
State means as a लक्ष्य. The state means any land or several fisheries or ferry rights included under one entry in any of the general registers of revenue paying lands and revenue free lands prepared and maintained under law for the time being enforced by the collector of a district, and includes revenue free land and several ferry rights not entered into the register into any register and share in or offence state. Now let's look and see tenure का definition 2Q में. Tenure means the interest of a tenure holder or an under tenure holder, and includes Ghatwali tenure, a tenure treated for the maintenance of a person or commonly known as Kharposh, Babuna, etc., and a share in or of a tenure, but does not include Mundari Kutkuttidar tenancy, which within the meaning of Chotnagpur Tenancy Act, or Niyari tenure prepared and confirmed under the Chotnagpur Tenure Act 1969. And now can we see the definition of tenure holder? Tenure holder means a person who has acquired from the proprietor, from a proprietor or any other tenure holder, the right to hold the land for the purposes of collecting rent or bringing it at a cultivation by establishing tenants on it, and includes such and such. So Lordship, the basic state जो आप बोले थे कि मेरा अपना property जो हम रखेंगे, that is my state. And tenure holder right is the property which I have kept for the purpose of collecting rent or getting it
Let
cultivated.
me just have a look at the plaint.
Yes. Lordship, para 1 से ही पढ़ दे रहे हैं. The land situated in Mauja Ranguni within Katras police station along with other lands originally belonged to or was in possession of Chandra Mohan Datta, son of Ishwari Chandra Datta, his nephew Sambhunath Datta, son of Shaurya Mohan Datta, and Sasibala Dasi, wife of late Srishtidhar Dasi, are permanent tenure holders right, each having 2 annas as interest on the Mauja. So I had a share of collecting rent up to 2 annas, which was later on recorded as such in the last registration.
Everybody?
That while thus in possession, Chandra Mohan Datta took loan by mortgaging his 2 anna as interest in the Mauja from Murlidhar Paul, predecessor in interest of the plaintiffs, and former defendants Haribol Paul, who filed title mortgage suit number such and such against Chandra Mohan Datta for in the court of subject Dhanbad, which was decreed on 23/11/29. The said decree was put into execution in execution case number 492 of 1935, and the property was publicly auction sold and purchased by the decree holders on 18/3/37, who obtained the possession through court on 18/6/37, and since then remained in peaceful possession thereof. That Sasiwala Dasi died issueless.
That's right.
Yes.
अब आप इसको मंडे को कंटिन्यू करेंगे. 1964 का भी सही लीड है यहाँ पर।
हाँ
वो एग्जिबिट कौन सा है?
ये लोग अपने चार्ट बना के दिए थे सब्सिट्यूट से ऊपर में।
ठीक। Pose for further argument of respondent number 10 to 15 on Monday at 2. इसको ना उसके साथ बांधते जाइए, ये जितना भी कोई भी यूज सब बांधते, सब बांधते। आप लोग नोट्स बना रहे हैं साथ साथ? बना रहे हैं आप भी? हाँ, उसी में ऐड मॉडिफाई करते हुए वॉट एवर यू आर आर्ग्यूइंग। लेकिन अगर कोई भी बात जो आपने आर्गुमेंट में नहीं लिया है और अगर आप बोलेंगे तो हम आपका पूरा का पूरा नोट में कमेंट लिखेंगे दैट यू हैव मेड नोट्स एंड 5 notes which is not based on arguments advanced, and these are all recorded proceedings. आप मेरा बात को any time झूठा साबित कर सकते हैं।
Every day Lakshmi is recording it in the
Every day I am recording it and it is also recorded. नया कहानी नोट्स में मत लिखिए, एकदम मत लिखिएगा। कोई नया बात, कोई नया जजमेंट जो आप प्लेस नहीं किए हैं हम नोट्स में परमिट नहीं करेंगे, ठीक है? ऐसा नोट को हम तुरंत रिजेक्ट कर देंगे, डिस्कार्ड। जिसका भी ऐसा कोई ऐसा नया कहानी मत लिखिएगा नोट्स में। चलिए कुछ ऑर्डर्स है केस आपका क्या है? कौन है आप?
मिस्टर शैलेश को लगता है वो लोग एक ही है।
अच्छा। हो गया, आपका तो कोई रोल ही नहीं है। अच्छा
हम लोग का रोल आएगा, हम लोग जब इन लोग का कंटेस्ट खत्म हो जाएगा देन मिनट्स बिकॉज़ जुडिशियल ऑर्डर वी आर ठीक है लास्टली लास्ट में मिनट जब आईए भी कंक्लूड देन
एक दिन हम रखेंगे सारे आईए के लिए। आप लोग आईए का भी नोट्स बना लीजिए, ईच एंड एवरी आईए जो भी आपका आईए है। अभी हम किसी को रोक नहीं रहे हैं, कुछ नहीं कर रहे हैं। आप लोग अपने जब जब मन हो अपने फाइल करते जा रहे हैं। आई जस्ट डू नॉट नो, आई डोंट वांट टू कमेंट ऑन दैट बट और जो भी आईए फाइल हो रहा है अपना रिप्लाई फाइल करते जाइए, नहीं तो अनकंट्रोवर्टेड आईए रह जाएगा। तो आई से दैट देयर इज नो रिस्पांस टू दिस। आपके रिटन नोट्स ऑफ आर्गुमेंट बिना आर्ग्यू किए नहीं ले सकते हैं।
नोट यू विल आर्ग्यू आफ्टर दोस राइट ऑन द डेट व्हेन द आईए विल
व्हाट आर्ग्यू आपका तो लिखा दिए
और सबमिशन
कहने को नहीं
वी
है।
हैव टू आल्सो नोट से
किसको दिखाना है
नहीं नोट दिखाने के बाद
तो फिर जबरदस्ती आपको मौका दिए थे ना,
बट हमको
आपको मौका दिए थे।
बट हमको खाली 10 मिनट का टाइम चाहिए और कुछ नहीं। हम 10 मिनट में जो हमको आप बहस करना है हम कर देंगे और 2 पन्ना का रिटर्न आर्गुमेंट।
डिफिकल्टी होगा कि ये लोग फिर आर्ग्यू करेंगे बिकॉज़ दे आर ऑल
नहीं, आप लोग का सबका आर्गुमेंट रिकॉर्ड करने के बाद हम रिजॉइंडर चालू किए हैं, ठीक है? आपका जो भी आपका सबमिशन था आप बोले नहीं बस इतना ही हमको मतलब।
हम कल नोट्स मिस्टर शैलेश से पूछा गया कि वो बोलने लगे कि हाँ इनका राइट और ये तब नोट्स ये हुआ कि हाँ आप कैसे क्लेम कर रहे हैं। खाली उतने ही नोट्स हम कैसे
देखिए आपका ना तो कोई रिटन स्टेटमेंट है, ठीक है? आपका कोई स्टैंडिंग है ही नहीं। आपका टोटल स्टैंडिंग है प्लेंटिफ का केस, ठीक है? प्लेंटिफ अगर डूबेगा तो आप डूब जाइएगा।
नहीं वैसे अगर कहा जाएगा हुजूर तो जब प्लेट में हमारा रिटर्न स्टेटमेंट की बात उठाते हैं और वन सब रूल 4 की बात आएगी. Length has to be amended. Parties have to be added.
I do not.
That is not the
हियरिंग
situation.
चल रहा है, वो कुछ भी सिचुएशन नहीं है. हमको रिमांड हुआ है, एक टाइमलाइन दिया गया है,
Yeah.
हियरिंग इतना दिन से चल रहा है, और अगर इस वक्त आपको मन कर रहा है रिटन स्टेटमेंट फाइल करने का तो
I
आई
am not asking for that. I am submitting. Not 2 lines. I will be submitting nothing more or nothing less.
2 लाइंस अभी सबमिट
One
कर दीजिए,
written
10
statement,
मिनट.
written notes of
But
argument.
how-
नहीं नहीं, आप इस तरह से हम आपका रिटन नोट्स ऑफ आर्गुमेंट नहीं लेंगे.
That is how we have filed.
नहीं नहीं, फाइल करने से क्या हुआ? इफ यू डू नॉट आर्ग्यू, तब तो हम भी ऐसे थोड़ा
No, no. This is the 4 pages argument. I can conclude it. 5 minutes.
बोलिए
Not
आप.
10
One
minutes,
more
10
point
minutes
is,
time only, nothing more.
this
I'm
is
asking.
the order sheet dated 18th March. 14/12/2018 where been implemented. This much I have to highlight. That's
तो वो तो हम ऑलरेडी हाईलाइट कर चुके हैं, उसमें क्या करना है? दैट हैज ऑलरेडी बीन रेफर्ड. आई एम कॉन्शियस
No,
ऑफ दिस
this very
फैक्ट.
particular order.
यस जिससे
Okay.
आप लोग इम्प्लीड हुए हैं, जिसमें लिखा है कि यू विल देयर इज नो.
Subservient to the Paul.
That's
brothers.
it.
Yes.
ओके, बस इतना ही तो.
Yes, yes, yes.
और तो कुछ है ही नहीं.
But तो अगर इनका हो गया तो हमको खाली 10 मिनट का कोई भी दिन नोट जब
नहीं नहीं, कोई भी दिन नहीं है ऐसे.
But only 10 minutes.
After conclusion.
After conclusion, your lordship may grant me 10 minutes because I am
Do
also
one thing
party.
then. Lordship,
In a
on Monday let them argue for 10 minutes. Thereafter we'll start so that I
आप
can.
मंडे को 10 मिनट्स अपना आर्गुमेंट कर लेंगे. 10 मिनट्स मतलब 10 मिनट्स, पूरा समय मत
बस
लेंगे.
10
और नहीं रहिएगा टाइम पर तो फिर इनका आर्गुमेंट चालू हो जाएगा.
बट हम एकदम टाइम पे 2:15 ही में आ जाएंगे 10 मिनट कम कर
Is that we
हमको भी वही 10 मिनट मिल जाना चाहिए.
अभी तो लड़को
आप तो पहली बार अवतारित हुए हैं इस केस में, आपको तो क्या ही पता क्या चल रहा है.
हमारा रिटर्न नोट्स ऑफ आर्गुमेंट.
आपको तो मालूम है क्या है कि आप क्या क्या बहस हुआ, आपको तो कुछ नहीं मालूम.
वही चीज जो ये कह रहे हैं तो वही हम 10 मिनट वही करेंगे. अपना रिटर्न नोट्स ऑफ आर्गुमेंट.
फर्स्ट अपील रिले रेस नहीं है.
नहीं हम ये
इट्स
कह
नॉट
रहे
अ रिले रेस कि अपना जो है डंडा किसी और को पकड़ा दिया, उसके बाद घूम रहे, फिर घूम के आपका नंबर आएगा, ऐसा
हैं
नहीं.
ऐसी कोई बात नहीं है. We know fully well our interests are subservient to the Paul's interest. That is, they are both contesting. No relief has been sought for as against us also. Now the contest in between him and myself is pending before the court below 1092.
तो हो गया. देखिए कल आप नहीं थे ना, इसीलिए आपको कुछ नहीं पता, इसीलिए बोल रहे हैं बीच में मत घुसा करिए प्रोसीडिंग के. जिस प्रोसीडिंग को आप सुने ही नहीं है, जिसके बारे में आपको
नहीं,
मालूम
अर्लियर
नहीं.
जब हुआ था तब तो थे इसी में थे.
और ये तो फिर अर्लियर का तो सेट असाइड हो गया ना.
हाँ,
तो इतना ही कॉन्शियस रहते तो आईए वगैरह सारा प्लेस हो गया रहता उसी समय. ऑर्डर्स का केसेस है कुछ, कॉल करिए.
अब सप्लीमेंट्री लिस्ट
ऐसे
ऑर्डर्स आइटम
अनकंट्रोल
4.
प्रोसीडिंग नहीं चल सकती.
Item 4, first April 3 of 2025.
What is it?
For
क्या?
serving of notice, last time for second time notice was to be served to respondent number 3, 4, 9 to 13, 27, 84 and 93.
Sorry, SR received with report that respondent number 310.
84 have received in person.
Yes.
Respondent number 4 has received by his brother.
Hmm.
And 11, 12, 13 has been received by the nephew. And for respondent number 9, 27 and 93, there is no confirmation.
Is it
Neither
a-
service report nor undelivery report has been received.
नहीं, respondent number और किसका है? यही तो है. 11, 12, 13 और कौन बचा है? That's it. 3, 10, 84.
Yes. 384.
Then 4.
Yes. 4,
11, 12, 13. अभी और किसी का वेटिंग है?
Waiting in 9, 27 and 93.
9,
27 and 93. The
27,
report has not been received yet. Whether it's delivered or not.
90.
93 was sent by police.
9, 27 and 93 is also there.
Yes, immediately report was served through police station. Because his whereabouts are unknown completely.
9 का भी नहीं है, 27 का भी नहीं है, ये लोग ऑफिस नोट पे क्यों नहीं लिखे हैं 9, 7 and 23 के बारे में? यहाँ पे क्या फ्रेश ऑफिस नोट बनाए हैं? 10 तारीख को फ्रेश
27 का है
27, 19, 19, देखिए FA number 3 of 2025. As per the office note, notice has been received upon respondent number 31084, 4, 11, 12, 13, either by themselves or through their close relatives. The learned counsel submits that the notice may be accepted as validly served. Considering the submissions, the notice upon their portrait respondents is accepted as validly served. Submits that as per the service report, notice upon respondent number 9 and 27 could not be served as they are not residing at the given address. Notice upon respondent number 93 was issued through the concerned police station, but service report has not been filed. Has not been received. Counsel for the appellant is directed to take first steps for service of notice upon respondent number 9 and 27 at their present and correct address. Office is directed to since the service report of respondent number 93 has through the concerned officer in charge Tirkunda police station Dhanbad has not been received, office is directed to send a reminder to the aforesaid authority to send the service report. हमको तो नहीं दिख रहा वहाँ से कुछ भी नाज़िर का report है। इसमें तो कहीं नहीं है।
Notice upon 9 and 23.
Post on 4th September.
For 9 and 23, notice will be served to ordinary person.
9 and 27 ordinary process at their present and current address. Requisites to be filed within 2 weeks.
date.
ठीक है, कार्ड कॉल करके देखते हैं।
From date list, Corridors item 8, 7 52 of 1020.
RTS क्या होता है? What is RTS? समीर जी, RTS क्या लिखते हैं?
In this case, the office report says that the so far the other respondents except are three sister 1 and 2 self, respondent number 4 wife self, respondent number 3 sister-in-law, 5 and 7 self, 8 not found.
8 not found.
8 not found. They are of the same family and it relates to
As per the office note, the notice upon respondent number 3 and 7 has been received by the state respondent or by their close relative at the request of at the prayer of the counsel for the applicant. The notice is accepted as validly served.
1 and 2 also self.
उसका 3 and 7 डाले ना, उसके साथ 1, 2, 4 भी डाले.
0. 8 के बारे में लिखते हैं not.
8 कैसे related है? Respondent number. 8 is a different person altogether.
Different person is a purchase.
Let fresh notice be issued upon respondent number 8 at his present and correct address, for which requisites under ordinary process be filed within a period of 2 weeks. 2 weeks from today. 6 का थोड़ा वेट कर लेते हैं. 6 कौन? Wife
no,
of Sanjay
no
Kumar.
service report is received so far 6 is concerned as per the office.
6 is wife of Sanjay Kumar.
Yes, he has Sanjay Kumar.
And 7 is also wife of Sanjeev Kumar,
Sanjeev Kumar.
daughter of late Motilal. कोई अपेयर नहीं हुआ इनकी तरफ से?
नहीं. All
ये
are
जो है ना
related with each other.
6 का भी कर दीजिए फिर से. 6 का भी प्रेजेंट एंड करेक्ट. नहीं तो
So,
ये
6
होएगा
and
ही नहीं. 6 and 8.
8.
They are avoiding to receive notice. ये क्या कर?
6 is of the same family.
सेम फैमिली है लेकिन कर लीजिए.
हाँ, कर.
पोस्ट ऑन 4 September.
4.
4 September.